Good morning, everyone, and welcome. I'm Jennifer Camilio with Corporate Counsel Business Journal, and we're thrilled to be working with our partner, the American Arbitration Association, to present today's Tech Tuesday webcast, AAA IA Arbitrator, Fairness, Efficiency, and Trust Reimagined. Our distinguished speaker today is Diana Didia, Executive Vice President, Chief Technology and Innovation Officer for American Arbitration Association. We encourage you to ask questions using the orange Q&A icon. Fill out the survey with your feedback using the pink clipboard icon. And if you're interested in the presentation and additional materials, you may download them using the blue paperclip icon. And all of those icons are located at the bottom of your screen. And now it is my pleasure to pass it off to Diana. Diana, take it away.
Thank you. Good morning, everyone. Happy Veterans Day. I'm really excited to talk to you today about the American Arbitration Association's AI Arbitrator. I'm going to talk about why we built it, what it is exactly, and how it's very different than other AI co-pilots, legal co-pilots in the marketplace. So first of all, I think it's important to set a baseline here. I think we've all used ChatGPT or some of the other large language models on the market. If you personally use them, you see that they hallucinate. They can be, provide misinformation. And so you may be asking, if this is the state of these models of AI, how are we using it for such a high risk use case as arbitration? It's very important to point out that what I'm calling it the difference between public AI and governed AI. And in governed AI, technologists such as myself have a lot of tools that we, at our behest, to institute guardrails around the way the AI operates, whether that is the way the prompts are written, prompt chaining, limiting the data set that it can interrogate to give its result. And when we put all these guardrails in place, we really do see that these models perform at the level of human accuracy. So that is the big difference, public AI versus governed AI. And as I walk through what we've built here, I'm going to be telling the story of how it's governed in addition to just how it works technically. So as I mentioned, governed AI allows us to get past sort of these concerns about the state of AI, but still, why did the AAA decide to jump out front and really be one of the first organizations using AI to decide a legal case? We felt, first of all, we have really bought into how disruptive this version of AI is going to be for the legal profession. It is exceptionally good at foundational legal tasks like researching, reading documents, writing briefs, developing contracts. We really felt like someone else was going to do this if we didn't, and that we sit on a lot of arbitration data that allowed us to really test this very well to ensure its accuracy. And we also, as a mission-based organization, are really committed to a formal set of AI principles that include transparency, explainability, ensuring neutrality. And so we felt like it was almost our responsibility to do this so that we're doing it right. And we're introducing this type of use case where we're using AI for something as critical as deciding a legal case, that, we're not cutting any corners and that we're ensuring that all of those important foundational principles are met. All right, so at a high level, what is the AI Arbitrator? First of all, it is hosted on a very easy to use, intuitive self-service platform. So true ODR, for years we've been talking about online dispute resolution. That's what this is. So everything is done in app. The filers are filing themselves. There is a human in the loop validator, which I'm going to talk more about, and all of that is done in app as well. So it includes a lot of what you're seeing in legal AI solutions today, document summaries, timeline generations, but it is not just a legal co-pilot. So the big difference here is that we have architected it in a way that the AI is reviewing the case and it is recommending a decision. So it is, examining claims and evidence, and it is reasoning through the case and recommending outcomes that are then validated by a human in the loop arbitrator. The human in the loop arbitrator is the one signing the award, issuing the award. But they have been given the recommendations from the AI, and that is the big differentiator. So not just a co-pilot. This is really AI-led, if you will, and then the human is there as a guardrail to ensure accuracy levels. It's important to note that what just went live, we went live a week ago, is limited to two-party documents-only construction cases. Why is that? Why did we start there? As technologists, we needed a nice, tight use case to ensure, to make it easier for us to build the framework of which this operates on, and to, the way we were doing testing, if we had picked too many different domains, it would have been more complicated. So we have a lot of documents-only construction cases in our database. So it was there was a large portion of our caseload to work with. Also, construction cases are usually involve clearly documented contracts, payments, and scope of work issues. So a little bit less ambiguous in what the AI needed to examine and determine. So those are reasons why we wanted to start with this particular caseload. We are in the process of certifying what we've built now on other domain areas. And so coming quickly, into the new year, you'll hear about the ability to use what has launched on a broader set of dispute types. All right, so getting more into, this is the cool part, like, how does this actually work? Like, what did we actually build? This is all built on OpenAI models. We did not fine tune the models. At no time did any of our data, was any of it consumed into the OpenAI models to improve the base models themselves. What we have done is really built a set of agents. A digital agent is like a digital worker. It's an AI worker that has been designed to do a very discrete task. And we have digital workers that, these digital agents that parse claims, identify issues, analyze evidence, and draft awards. So, the filers put in all of their submissions, and these various agents are performing all the tasks and breaking things down into claims and issues and sub-issues. And then it's interrogating all the evidence and then coming up with these recommendations of outcomes. What's really cool about what we did here is that out of the box, OpenAI is actually pretty good at this kind of legal reasoning. But I like to say it is sort of like a newbie arbitrator. Like, it isn't really, trained in a particular domain and have the wisdom to really opine on more subjective issues. So the way that we overcame that is we actually used AI to interrogate over 1,500 construction cases. And we also worked with human arbitrators from the construction space of actually hours of interviewing them of how we had their reasoned award. We have all the actual human awards in our database, the complete set of case documents. And we were really going through and painstakingly document the decision-making process. Like, what did you look at first? How did you examine this particular claim? What were you looking for in the evidence to determine the merits of this particular claim? And we actually created a set of handbooks. We have a few. There are ones that focus on how arbitrators weigh and interrogate evidence. Another covers common legal issues and contract disputes. And a third guides award structure and clarity. And all of these digital agents, like an employee, they reference their handbook, and the handbook is giving them guidance as to really up its performance beyond just this generalist, and to really act like a seasoned arbitrator. An example that we use to show how this works is a quantum root claim where perhaps a homeowner is in a dispute with their builder, and they don't want to pay the builder because they believe the work hasn't been finished. But a subcontractor finished all the beautiful kitchen cabinets in the house and wants to be paid for the cabinetry work. In the initial run of this, the AI said that the homeowner did not owe any fees to the cabinetry builder because there was no contract between the homeowner and the cabinetry builder. But from a fairness perspective, an arbitrator would rule that the homeowner needs to pay the cabinetry maker for the kitchen cabinets that were completed and satisfactory, were satisfactory. That is in the handbook. So in the handbook, it tells the digital agent to look at the evidence first and to not be going to write, ruling on the claim by only determining if there was a contract in place between the homeowner and that subcontractor. And so the other point I maybe to mention here is I briefly touched on it, is this entire architecture, the way we were testing it was really comparing it to a set of highly deconstructed human issue awards. So again, we work with human arbitrators. It's sort of like a golden data set, a ground truth data set. And every time we were adjusting a prompt, we would run that same case through there and see how it performed against this human award that we had, highly tagged. And that iterative flywheel process, we really got this to perform at the same level that human judges or human arbitrators agree or disagree with one another. So it's really in that range. It's acting like a member of the tribunal and agreeing with the human arbitrator at the same rate that another human arbitrator would agree with that human. All right, so now I'm going to show you what it looks like, and I'll walk you through the filer experience and then also the human in the loop arbitrator experience of, so how this really works in practice. All right, so this is the logon screen for the filer. The lightweight ODR platform, we refer to that as the Digital Dispute Resolution Center, or the DDRC. This is the homepage where they would be selecting a construction dispute. Note, we did develop a set of rules specifically for this platform. They are called the AAA AI-led arbitration rules. In the future, that may be integrated into the regular AAA rules as a provision, but right now they are standalone. The rules, this is all opt-in. This is in the rules. No one has to use this process. If you're filing a documents-only construction case with us, you can still go through our regular filing system, and you have a human arbitrator deliberate on your case. So this is opt-in. You also have the choice up front to select whether or not you want the award to be binding or non-binding. We appreciate that this is all new, and that people may prefer to use this perhaps as a tool to drive settlement versus trying to get a binding award from this process until folks become more comfortable with the way all of this is working. So next, the filer is guided through a step-by-step filing process. It's a little bit like a TurboTax. And this was all developed with, we had pilots over the summer, and we had lawyers and law school students and arbitrators actually participate in simulations of this. So we really feel like we sort of really tuned what we felt would be the most efficient for both filers and the human in the loop arbitrator as far as the way the process and the screens are constructed. So what's really important here, I've been talking a lot about the human in the loop arbitrator, but actually the filers themselves are also a human in the loop. They are also a guardrail. And part of the transparency and explainability principles here that we've baked into the platform is that the filers themselves do get to see how the AI is parsing out and consuming their filing information. So as soon as they've uploaded their demand statement and begin uploading their submissions, there are screens like this where they see what the AI discerned, and they get a chance to correct it if they needed to correct it. In any place where you see on these screens where the human in the loop can edit something, we are ingesting that back into a centralized performance tuning dashboard that we have for this whole AI system, and the flywheel continues. Like, so if they edited this extensively, we would see that got a poor score in the back of our system, and we would want to know why. and we would be analyzing that and then using that as a continuous improvement loop for our AI agents. So we'll be continuing along with the filer experience. Here is a key step. At this point, this screen occurs when both, as the one filer, the claimant goes in, files, when they finish their submission, they've put in who the respondent is. The respondent gets an email. They're asked to respond. They also have to opt in. Both parties, again, all in app, are asked to submit their, finish submitting all of their evidence, their submissions for the AI arbitrator and the human in the loop. When they both have done that, they get to this point where they actually get a chance to see how the AI has summarized the case, all the claims and counterclaims, the summary of positions, the timeline, the key issues. We felt this was really important. Again, it's sort of allowing the filers, both sides of the coin here, to feel heard by the AI, so they really know how the AI has organized their case for the AI arbitrator and for the human arbitrator. So at this point, either party can give feedback on any aspect of this case summary. The feedback that they would give at this point does not go to the AI arbitrator. It only goes to the human arbitrator, the human in the loop arbitrator. And we felt that this was important. We didn't want to sort of bias the AI arbitrator at this point, but we did, again, want the human filers to feel that they were heard. And so the feedback on the right-hand side would go to the human in the loop arbitrator. All right, so now moving on to the human arbitrator experience. There is a permanent panel for this. Right now we have about 10 construction arbitrators that are assigned. While that submission process was happening and the AI is thinking through the case, this is all in the rules. There is a process, a round robin process to pick the human in the loop arbitrator. There is some automation of disclosures of conflicts of interest. And then also the human arbitrator has a chance to review at a high level the details of the case, who the parties are, and to make additional disclosures if necessary. And the parties can reject an arbitrator, and it would round robin pick the next arbitrator. So what I'm going to show you now assumes that the human arbitrator has been appointed, and they would get an invitation that they're serving on the case that they were just involved with doing the disclosures on. When they click on their invitation, they would be brought to this screen. This is what we call our award builder. And this is now going to have the human arbitrator partner with the AI arbitrator and seeing all along the outputs from the AI arbitrator. And then again, the human arbitrator has a chance to review, edit if necessary. They're validating and editing. They are the ultimate guardrail for the AI performance. So here you see the human arbitrator is given a complete case summary, case information, the documents, the highlights, and they can, at this point, they're just confirming that they agree with the claims that are being considered. And then they would continue, they would hit next. And every time they're moving forward, they're sort of triggering the AI to continue its analysis. So now here's the really meaty part of this, sort of, it really is like a muscular co-pilot for the human in the loop arbitrator. They're seeing now the recommendations of the AI, against, all of the claims. You're noting that it always cites back to the evidence, so they can dip in and out of the entire case record. They can go back and review the case record on their own if they wish to. On the right-hand side, there is an assistant, an AI case assistant. This doesn't give them new answers. It just allows them to more easily navigate through the case. If they're remembering a document that they'd like to review, they could ask the AI assistant to find the document for them. This also, if you note on the upper right-hand side, there's another tab here for the parties' feedback. That is where that they could click in and they could see where the filers had given their final feedback on how the AI had sort of organized their case for for the review of how the AI had organized their case before it had continued on its analysis. So assuming, again, the arbitrator can make edits here, same thing, if the arbitrator makes edits, their edits are weighted more than the AI's at this point. And then that, again, comes back into that centralized performance monitoring system that we've set up. And we're scoring this. We have evaluative metrics that we're using to score. Are they stylistically changing something, or are they changing the substance of the AI's reasoning? And they're the ultimate guardrail to ensure what's given out in the award is correct. But we're using that feedback to continuously improve the AI's performance. They had next again, and now they're seeing the actual claims. It's determined an amount. Again, the AI has cited its evidence. It took into consideration the feedback from the AI arbitrator, and the AI arbitrator here again could go through the award, the interest, the attorney's fees, arbitration fees, et cetera, and then they are continuing. And then finally, the AI is drafting an actual award. At this point, they can edit this. They can go backwards. We're not anticipating that they would be changing things at the end here. In theory, they could, but really, I think the arbitrators that have been part of this journey and that are serving on the panel understand that they're really sort of validating as they go along. And when they get here, this should really be in line with their thinking. They can certainly change it stylistically if they want to. Here, they would then click the sign and submit, and it is their name. They are signing the award. The arbitrators that helped us to design this felt at the end of the process that the way that this is designed really would save them potentially up to 40 to 50% of the time it typically took for them to review a documents-only case. All right, so you've seen the system. I want to talk a little bit more about governance. I did mention that every click, every piece of feedback, there's some thumbs up and thumbs down in there. All of that is in service of us continually improving the AI performance. I mentioned evaluative framework metrics that we determined. We actually did that in conjunction with McKinsey's Quantum Black team. That is their machine learning division, in addition to academics. So there are many professors at esteemed institutions that study the performance of LLMs in the legal space. And so, we weren't, just sort of determining that on our own. We were partnering with experts to come up with the way that we are measuring the AI's performance, both when we build it and before we put something into the system, and then also as it is running, continually measuring how it's performing and continually improving it. The other thing, the other piece I did want to stress that none of this none of the data during it or in the building of it was consumed by the AI models, by the LLM foundation models. It is, everything is within the AAA's account, if you will, of utilizing the OpenAI models. We do make calls to OpenAI, and the data does go there. That is akin to in a prompt. It's really akin to cloud services. The AAA's documents, even in our traditional case management system, are stored on Azure, for example. This is similar. We have the most restrictive retention policies in place. So really, OpenAI is not saving that information for any length of time on their servers. We have built all of this using the NIST a framework for cybersecurity. So we get high marks about our cybersecurity program in general, and all of the protections and all of the governance that we have around cybersecurity for all of the AAA systems is in place for this tool. We do have SOC Type 2 certification underway. You cannot gain compliance until a system has been running in your production environment for a number of months. So the actual certification process would take place in 2026, we're anticipating. And our AI governance framework generally, so I've been really talking about how we operationalized it and what we've done to ensure accuracy in this tool. But we do, coming up a level, and I mentioned some AI principles. We've spent a lot of time and energy with our legal team and other subject matter experts across the organization, developing a formal AI governance and framework that does, it starts with risk assessment and what are the required guardrails and how are we monitoring against them and so forth. And I actually feel like we've done a lot of leadership work in that space as well, like just the development of a governance framework for legal use cases, and something that we're going to continue to mature. But it is a very formal framework, and a very formal process went into developing it. All right, and then just quickly, I know we're coming up on time here, just the roadmap ahead. I mentioned that we are going to be expanding what is live right now beyond just construction. So that is, there's a lot of time and energy going into that right now. And the idea is that the AI Arbitrator that you see live could be used in short order for all new documents, for documents only case types, regardless of domain. So that's a goal going into 2026. Also, the AAA, we have our current systems. We call it Prism internally. You may know it as eCenter if you're a neutral or web file, all talking to the same system. That system is also due for replacement. Runs fine, but it's just on more antiquated technology. There's not a lot of opportunity for it to take advantage of a lot of the efficiencies of this chapter of AI. Since it is an aged platform, we are in the process of developing a brand new AI native arbitration case management system to go live at the end of 2027. So that would have tons of optionality. You could use a human arbitrator partnered with the AI arbitrator. We're intending to offer a lot of optionality of what level of AI our customers would want, but certainly taking advantage of AI for things like scheduling of hearings, making the arbitrator selection process more efficient. There's a lot we can do that doesn't necessarily relate to the legal reasoning part of an arbitration. So if you want to learn more, I hope you do, you can go to www.adr.org/AI Arbitrator. We will ask you to put your contact information in there, but there is a video that gives a much more fulsome overview of the screenshots that I just walked you through. And you'll see the image, and then certainly you put your contact information there, and we have individuals ready to just give you a call, answer any questions that you have, and to walk you through any aspect of this in more detail. I see there are a lot of questions. I know that we, I think, are out of time. I have a member of our marketing team and PR team online with me. We will get all of these questions, and we know who you are, and we will be very happy to respond to them via email. So thank you so much for your time today. I'm really proud of what we built, and I'm really excited to have shared it with you. So thank you. We hope you're in touch.